The Homeowners Association. For some people, it's this great thing that keeps the neighborhood looking nice and keeps property values up, but for others, well, it can feel like a never-ending list of rules. And that tension, it leads to some classic neighborhood disputes. Today, we're diving headfirst into one of those, and it's all about a flag on a front lawn. So, let's just get right to it. Can your HOA actually ban a political flag? I mean, if they can tell you what color you can paint your front door, can they also tell you what political messages you can display? That is the exact question at the very heart of this story. So, here's the setup. You've got a homeowner in a community called Carter Ranch out in Arizona. He decides to fly a Trump 2020 flag. Pretty straightforward. But then, the Carter Ranch HOA steps in and says, nope, you can't do that, it's against the rules. And just like that, you've got a classic standoff.
And believe me, this wasn't something that got sorted out overnight. The HOA sent out that first violation notice way back in May of 2019. Less than a month later, the homeowner fired back with an official petition to fight it. But the whole thing? It didn't even get to a real formal hearing until January of the next year, 2020. This thing dragged on.
Okay, so let's dig into the homeowner's side of this first. His entire case, and I mean his entire case, was built on a very, very specific reading of the HOA's own rulebook.
And here it is. This is the core of his whole argument, pulled right from his legal petition. He's pointing to the community's main rulebook, the CC&Rs, and he's saying, look, the rule you're using against me, Section 3.14, it only talks about signs. He argues that the word flag is literally nowhere to be found in that section. So let's just break his logic down. It's a really simple three-step argument. 1. The big original rulebook only restricts signs. 2. He's flying a flag, which he sees as a totally different thing. And 3. Because of that, the HOA can't just invent a new rule about flags and pretend it's covered by the old rule about signs. He's basically saying they're overstepping their authority.
All right, so what did the HOA have to say about all this? Well, their defense didn't really get into the whole flag versus sign debate. Instead, they focused on something much bigger, their fundamental power as an organization.
See, the HOA pointed to a whole different part of their rulebook. This bit from Article V gives their board some really broad power. It says they can adopt, amend, and repeal rules for the health, safety, or welfare of the owners, and that, they argued, is all the authority they need.
So the HOA's counter logic went something like this. Step 1. Our founding documents say we can make new rules whenever we think it's for the good of the community. Step 2. We use that exact power to create a very specific flag display rule. And therefore, Step 3, that new rule is totally legitimate, and we can absolutely enforce it.
But here's where it gets really interesting. This wasn't just a little neighborhood spat over a rulebook. The homeowner's whole case was built on the idea that the HOA had actually violated state law. And that changes everything. It means this isn't just a dispute anymore. It's a legal case, and the homeowner now has what's called the burden of proof to show the HOA broke the law.
And it all comes down to this one specific law, Arizona Revised Statutes, Section 33-1808. When you get to this level, a judge can't just rule based on feelings or what seems fair. Their decision has to be based on the exact words written right here in this statute. Okay, so check this out, because the law gets really specific and kind of weird here. On one hand, it explicitly protects a homeowner's right to fly certain flags. We're talking about the American flag, military flags, the Arizona state flag, even the Gadsden flag. But then, it treats political signs completely differently. The law says HOAs can regulate those, like they can limit their size and say you can only have them up for a certain time around an election.
So here it is, the million-dollar question. The law protects some flags. It regulates political signs. But it is completely silent on the idea of a political flag. So what is a Trump 2020 flag? Is it a protected flag or is it a regulated sign? The law just doesn't say. And that ambiguity, that little gap, that's what this entire case ended up turning on.
So, the stage is set. We've heard the homeowner's argument about signs versus flags. We've heard the HOA's defense about their power to make new rules. We've looked at the gray area in the state law. After all of that, the administrative law judge had to make a final call.
And the verdict? Bam. Petition dismissed. Clear and simple. The homeowner lost. The HOA won. But to really get why, we have to look past that one-line verdict and into the judge's actual reasoning.
And the key to the whole thing is a legal concept called the burden of proof. Basically, it just means that in a legal fight, one side has the job of proving their claims are true. In this hearing, that job fell completely on the homeowner. It wasn't the HOA's job to prove they were right. It was the homeowner's job to prove the HOA was legally wrong.
And when you read the judge's decision, you can see how this played out. The judge basically said the homeowner failed on 3 huge points. 1. He didn't prove the HOA's new flag rule went against their broad powers. 2. He didn't prove they created that rule the wrong way. And 3, and this is the big one, he never actually showed how the HOA's rule violated that specific Arizona state law.
So, here's the bottom line, the crucial point. The homeowner's entire argument was about his personal interpretation of the HOA's internal rulebook, that whole flag versus sign thing. But his legal case was supposed to prove that the HOA broke a state law. He just never connected those 2 dots, and because he couldn't connect them, he failed to meet his burden of proof.
And that really brings this whole story home, doesn't it? This case is such a powerful reminder of how much the tiny, specific details in your HOA documents and your state laws actually matter. It shows that what you think the rules are might be completely different from what they actually say on paper. Which, it leaves us with one last question for you. Do you really know what your rulebook allows?